Next, we will be discussing Hurley versus the Assessors of Quincy. This is an ATB decision concerning an appeal from the refusal of the Board of Assessors of the City of Quincy to grant a real estate tax deferral under General Law Chapter 59, Section 5, Clause 41st A. The issue is whether the assessors properly denied an application for deferral of real estate taxes because the taxpayer did not file a mortgage permission document with the assessors. Before we jump into the facts of the case, what is Clause 41A? In essence, General Law Chapter 59, Section 5, Clause 41A allows qualified seniors who meet certain income and other requirements to defer all or part of their property taxes. This deferral generally will continue until the passing of the taxpayer or the sale of the property. Qualifications as of the July 1 eligibility date include, in part, age, ownership, domicile, gross receipts, a certain deferral amount, and entering into a deferral agreement. In 2018, the Globe called 41A deferrals one of the best kept secrets in Massachusetts because of how rarely it is utilized throughout the Commonwealth. So it is rare we see a decision from the ATB or courts concerning Clause 41A. So the facts of the case. In 2011, taxpayers who had occupied the subject property as their home for several decades applied to the assessors for a deferral of their real estate taxes. The assessors determined that the taxpayers exceeded 65 years of age, met the domicile, residency, maximum gross income, and that they met the other requirements under Clause 41st A. The assessors therefore allowed the deferral application. As required under 41A, the taxpayers entered into a tax deferral and recovery agreement with the assessors. Under the agreement, the assessors agreed that real estate taxes on the subject property would be deferred beginning in fiscal year 2011 until the subject property was either sold or the owners of the property passed away. At such a time, the taxpayers or their heirs would repay the deferred taxes together with interest. Sometime after entering into this agreement, the taxpayers executed a reverse mortgage. Thereafter, taxpayers were required to file an annual application for deferral to establish that gross receipts were below the statutory ceiling. This process occurred for 8 years. Then, in 2019, the appellant's husband sadly passed away. Soon thereafter, for the annual application for 2019, the assessors requested, in part, evidence that the holder of the reverse mortgage granted its permission for the deferral of real estate taxes for the fiscal year at issue. In the end, the assessors received a timely filed abatement application and voted to deny the same. The reason stated on the second denial notice was no mortgage permission. It was not granted. As a result, the assessors determined that the first 3 quarterly payments of real estate tax were delinquent. Moreover, the assessors contacted the taxpayer's mortgagee directly to inform them that the taxpayer's real estate taxes were no longer deferred and that the assessors considered all deferred taxes to be due and payable. As such, the taxpayer's mortgagee drew down mortgage proceeds that had been allocated for the taxpayer's living expenses and paid the real estate taxes on the subject property for the fiscal year at issue, as well as the taxes for the 8 prior fiscal years that had been deferred. These amounts included a 14% delinquency interest rate for the real estate taxes for the fiscal year at issue 2019, and a 4% rate for the 8 prior years. The ATB further noted that as a result of all of this, the taxpayer, a widow in her 80s, who relied upon the reverse mortgage proceeds for her living expenses, was forced to sell the subject property, which was her family homestead for approximately 50 years, where she and her late husband raised their family. So what did the ATB rule? The board found and ruled that the assessors had no basis for denying the taxpayer's deferral application. First, the ATB says there is no requirement in Clause 41A that a, quote, mortgagee permission letter, end quote, accompany the taxpayer's application. The only mortgagee approval that is necessary under 41A is a, quote, written prior approval, end quote, for a deferral agreement, which written approval shall be made part of such agreement. In the present case, the agreement was executed in May of 2011 prior to the execution of the reverse mortgage, and therefore no prior approval was needed. More importantly, there was no requirement for a post-agreement mortgagee permission letter. Further, there is nothing in 41A or the agreement that allows the assessors to accelerate the payment of the taxes deferred between 2011 and 2018. Both the statute and the agreement provide that only two events trigger a repayment obligation. That is, the sale of the subject property or the death of both the taxpayer and her husband. Neither event occurred when the assessors demanded payment of the fiscal year 2011 through 2018 taxes. The question remained, however, as to the appropriate remedy in this appeal. Because the sale of the subject property was scheduled to take place approximately 2 weeks from the ATB hearing date, it would have no practical effect to order the repayment of the deferred taxes back to the taxpayer, since they would have to be repaid at the closing pursuant to 41A in the agreement anyway. The board did add that the most significant harm caused by the assessor's actions was forcing the taxpayer to sell her home before she intended to, but the board is without jurisdiction to remedy that harm. However, the assessor's erroneous denial of the taxpayer's deferral application resulted in a tax liability in excess of what she would have owed for the fiscal year at issue 2019. Had the assessors properly granted the taxpayer's deferral application, her tax obligation would have been deferred at an interest rate of 4%. Instead, the assessors erroneously determined that the taxes were delinquent and imputed a rate of 14% on her real estate tax for the fiscal year. The board, therefore, in the end, issued a decision for the taxpayer and granted an abatement in the amount of $848.63, the difference between what the taxpayer was charged for the fiscal year at issue and what was due under 41A in the agreement. So the main takeaways here. The ATB ruled that reverse mortgage permission is only required when entering into a 41A agreement in the first year of the deferral. If the reverse mortgage is subsequent to the agreement, permission is not required for the granting of the deferral per the statute. This case also emphasizes that there are only two events that trigger the repayment obligation under 41A, and that is the sale of the subject property or the passing of the taxpayers.